Okay, everyone. So before the shutdown happened, we were working our way through the three branches of government. So we had covered pretty extensively the legislative branch, and we've talked a decent amount about the executive branch. And so today this week, we're going to finish up the three branches of government and understanding their roles and responsibilities, how they work together, and sometimes how they work against one another by tackling the judicial branch, right? The Justice Branch, Article 3, right? So if you look at your pocket constitutions, the first thing you'll notice about Article 3, and we noticed this a while back, is that it's maybe a paragraph, 2 paragraphs long. Compare that to how long Article 1 is and Article 2 is. It shows you a little bit about the thinking of the founding fathers about the role and importance of those branches, right? So Article 1 being the longest and most detailed about what Congress can and cannot do. Article 2 being detailed, but also not having nearly as many powers as the legislative branch. And then Article 3, you will notice it has very specific, specified, delegated powers, very limited powers. Right, and the purpose of this was remember the Anti-Federalists were very much concerned about having a judicial branch that could overrule the popular opinion of the people, which would be coming through the Congress, right, the people's branch. So they made sure to give it a very clear and concise mission, and that mission is to protect the Constitution. So, like I was just saying, the judiciary branch is the guardian and interpreter of the Constitution, meaning when a Congress passes a law or the president enacts a policy, the judiciary is there to ensure that those actions do not in any way violate the Constitution and thus violate the rights that the Constitution has enshrined for us. Key point to keep in mind here is this concept of rule of law, meaning that prior to the Enlightenment period, there was no such concept of rule of law, meaning kings could violate rules. They could kill people, they could murder, they could steal, they could embezzle, they could do all sorts of things, and they couldn't get in trouble for it because the world existed around them. Under the enlightened philosophies of the revolution, that changes to the concept of rule of law, meaning no man, king, queen, president, congressman is above the law, and that both the governed and the government should be subject to the law. Meaning, we need some sort of tool to use to enforce that, and that is the judiciary. So, if you take out your pocket constitutions, dust them off, and turn to Article 3, you'll see that the Constitution only creates one level of court, right? The Supreme Court. But you'll know that for anyone who's had to go get a parking ticket or a speeding ticket, or we have other courts, right? Not all legal matters are solved by the Supreme Court, and that's because Congress can establish lower courts, and they have. And in a subsequent podcast, we will talk about the different levels of court, right? The Judiciary Act of 1789 is where a lot of the current federal court system comes from. Excuse me. And the Constitution created it as an independent judiciary, meaning they are not elected by the people. They serve lifetime judgeships. The point of this being, this takes away any perverse incentives for the judges to rule in what they know to be an incorrect and unconstitutional way so that they can maintain their seat, right? So if their sole job is to look at a piece of legislation and say whether it is constitutional or unconstitutional, they need to be able to do that without fear of retribution. So let's give an example. Let's say Congress passes a law banning religion. And let's say for whatever reason that is an extremely popular law. The judiciary has the obligation under its mandate by the Constitution to strike that down, to say, no, this is unconstitutional, citing the First Amendment of the Constitution, the right to free religion. So if they were not appointed and lifetime served, if they were elected every 2, 4, 6, 8 years, then if they ruled against that very popular piece of legislation, their constituents, the people, the United States of America, would probably vote them out of office. So, because Madison says if men were angels, there would be no government, and we understand that all men are flawed, the incentive there for the judges would be to rule in favor of the unconstitutional legislation, which inherently violates the Constitution and violates your rights. So the judiciary wouldn't be able to serve its core function. So this is why they give lifetime appointments and protected salaries, because if they rule a way that, let's say, 57% of the population doesn't like, the population can't do squat about it. They have to just suck it up because the justices are there until they decide to retire, or if they are found to have committed some sort of malfeasance or wrongdoing. So if we look back to how the founders thought about the judiciary, again, we look at the very brief writings at the time, right? And we looked at Hamilton's writing in Federalist number 78 weeks ago. We'll kind of rehash it a little bit here. Quote, "The executive not only dispenses the honors, but holds the sword of the community. The legislature not only commands the purse, but prescribes the rules by which the duties and rights of every citizen are to be regulated. The judiciary, on the contrary, has no influence over either the sword or the purse. It may truly be said to have neither force or will, but merely judgment." So, what does this mean again? Well, the legislature not only commands the purse, but prescribes the rules. They can tax and they make the laws. The judiciary, on the contrary, has no influence over the sword or the purse. It can only have judgment. So, Alexander Hamilton was writing this in 1788 in response to anti-federalists' concerns about a federal court system coming into the state of Georgia and telling them that they have to change their laws. So he and the other founders crafted the Supreme Court to not have the ability to force a state or a piece of legislation to go away, but just to say essentially, hey, by the way, state of Georgia, Congress, this law is not constitutional, so we recommend you change it. This way, it satisfied the anti-federalist worries about an all-powerful federal government, but it also gave some sort of check on unconstitutional behavior. Now, we know that's not the world we live in today, and we're going to kind of talk about that here in a second, about how the Supreme Court got much more powerful in the 200 and something years since its establishment. And that happened in the case in 1803, Marbury versus Madison. So the right for the courts to overrule and throw out a piece of legislation was an inferred power that the court gave itself during this Supreme Court case. So, John Adams, our second president, he loses re-election to Thomas Jefferson. They are of different political philosophies, different political parties. In the final days, Adams is attempting to rapidly appoint his loyalists to government posts, so that when he left, that Jefferson would have to work with Adams, people who believed the same things about government that Adams did. So a man named William Marbury was to be appointed, but the appointment wasn't completed when the presidency of John Adams ran out. So Jefferson shows up and he says, I don't want you guys. I want my own dudes. All right, so he kind of throws out Marbury's appointment. Marbury, ticked off about this, wants his government gig, goes to Congress and invokes the Judiciary Act of 1789. And the Judiciary Act, amongst other things, allowed the Supreme Court to, quote, issue orders against government officials. So Marbury essentially tried to use the Supreme Court to force Jefferson to give him the job. This is where it gets fun. Now, Chief Justice, or the head justice, John Marshall of the Supreme Court, realizes that this act of Congress that Marbury invokes conflicts with Article 3, because Article 3 of the Constitution does not say anything about the Supreme Court having the power to force another branch of government to do something. So now we have a quandary. Does the court follow the law, the Judiciary Act, which says, hey, use your power, Supreme Court, to force another branch to do something? Or do you follow the Constitution, which it does not say anything like that? So they had to make a judgment. Now we know where this goes because we know the Supremacy Clause, and we know that the Supremacy Clause of the Constitution says that the Constitution is above all else, above law, above state, above local actions. All right. Now we'll see what happens. So the Supreme Court finds that the Constitution, like I said, is a fundamental and paramount law of the nation, and that any piece of legislation repugnant or that goes against the Constitution is invalid and void. That phrase right there, invalid and void if a piece of legislation is repugnant or goes against the Constitution, establishes this idea, vocabulary, of judicial review. The power to declare national, state, and local laws invalid, not just wrong, but invalid, meaning they are no longer laws if it is in violation of the Constitution. So this gives the Supreme Court a massive amount of power that they originally did not have. And it helps the Supreme Court to become the court that we know it today, right? And it becomes the final authority on the meaning of the Constitution. So now the question is, now that the Supreme Court has massive amount of power, we need to decide how are they going to use it. And so there's kind of two schools of thought on this. You have this concept of judicial restraint, which means that the court shouldn't just be popping its head into every piece of legislation, action, policy, that they only need to, use it sparingly, right? Because they believe, people who believe in judicial restraint, that the Congress, which is the people's branch, are elected by the people, should be making policy decisions and not unelected judges, because we are, while not a true democracy, we are a democratic republic, and that legislation that directly affects the people should be decided by those legislatures who are elected by the people. And so if you're thinking politically, conservatives to the right side of the aisle tend to believe in judicial restraint more in certain cases. Other cases, not so much. The other side of the coin is this concept of judicial activism. And so judicial activism is the idea that the court has a right and obligation to use its powers to overturn laws, right? So if there's a piece of legislation, let's say like Jim Crow down in the South, where Black people could only use certain water fountains, sit in parts of buses, eat at certain restaurants, judicial activists would say that is an inherent violation of their rights, and so it is the obligation of the court to go in and to overturn those laws because those laws are repugnant to the Constitution. They also kind of view the Constitution more as a outline or as a suggestion, and that that they believe that there's a lot more wiggle room for actions by the government within the Constitution. Whereas judicial restraint says, okay, it says government shall not infringe upon people's rights to own a gun. Okay, that's pretty clear. You can't have gun regulations or not, over the top gun regulations. Whereas judicial activists believe, well, let's read into it a little more. They also talk about common good, the welfare of the people. So we can add these pieces of policy and regulations. All right, so these people are much more on the left side of the aisle. Democrats, progressives typically believe in using the court's power to push the country in the direction that they would like. Okay, so I'm at 14 minutes, and that's perfect. So I'm going to stop here for today. Complete the attached graphic organizer for this and the kind of comprehension questions, and then we will touch base the next time I see you. Hope you all are well.